Good afternoon, Alan and Elise. Thank you for coming into my office this afternoon. As you know, we've been working together over the past 6 weeks in identifying information and data so that we could develop a comprehensive financial plan for you. In our initial meeting, you identified specific goals, objectives, and questions regarding your financial future and stability of your current financial state. In our analysis, we were able to identify and address and develop a plan for all of those elements that you had questions regarding. Because of the extensive nature of a comprehensive financial plan, I don't have the time to review all of those elements with you today. However, I did select at least one element that I would like to address with you because I feel that it is one of the largest potential liabilities within the financial plan. And that being said, that area is an estate plan. As you guys are aware, an estate plan allows you to put in the tools so that your assets move smoothly from one destination to where you intend the destination to be if something were to happen to either one of you. The goal is to avoid probate if possible. The probate process is a court-supervised process of gathering a deceased person's assets and then distributing them to creditors and inheritors. Typically, we see that assets that end up in a probate process are eroded over time by attorney fees, state fees from the courts, and a multitude of other fees. So it's very important that we avoid the probate liability that you have, and you can do that in several ways. One is by proper account registration. For example, in your guys' cash checking and savings account, you have a registration of joint with rights of survivorship. With the joint of rights of survivorship, if anything were to happen to either one of you, it would pass on to the other spouse. This is a very smooth transition. However, in accounts where you do not have joint with rights of survivorship, there is a possibility that it could go into the probate process. You guys have several accounts as such. Your investment accounts, at least your investment and retirement plan, Alan's investment and retirement plan. However, Alan's IRA does have a beneficiary. And because it has a beneficiary, therefore it will not end up having any of that $9,000 allocated into the probate assets. However, when evaluating the probate assets, you currently have $550,000 that would be into the probate process. And that's because there's either no beneficiary identified or for instance, the life insurance policy was $75,000 remaining. It's the estate as the beneficiary. Well, the estate would go through the probate process. With that being said, I would also recommend to you guys that you look at a will. A will goes into effect only after death, and this document will direct who will receive the property, and it'll allow you to appoint legal representation to carry out the wishes of the will. In the will, you're able to name your executor. The executor will know the state requirements or documents that need to be filed. Typically, an executor is your spouse, along with a contingent. The executor of an estate is an individual who should possess some level of business or investment experience, along with a core competent level with integrity and things that align with your level of interest so that it gets executed properly and the assets get allocated the way that they should. A trustee is an individual who should possess record-keeping skills and tax skills. Much of the details will be on the trustee's side. They manage the assets, they handle and distribute. They have to exercise good judgment and be trustworthy. The will will also allow you to identify a guardian for your minor children. Now, this individual should be sympathetic or empathetic with your wishes and be a very good caregiver for your children. I know that you have identified Sarah to be that, but the will allow you to also identify a contingent if at the time of passing Sarah was not capable of providing the care that you guys have outlined in your will. Another area where you have an opportunity is a durable power of attorney for your health care. In the case that something were to happen to you, you want to have the power of attorney understand your wishes, especially if you're facing a situation where imminent death is on the table. It'll allow that power of attorney to execute life support or no life support. So it's a very important element to have in your estate planning process. You also have an opportunity for a letter of instruction. And due to the complexity of your family, you can outline the specific instructions that you have with assets. And the letter of instruction will give guidance to the executor and trustee so that those assets get allocated properly. In your case, Alan and Elise, I really recommend looking at a revocable living trust. A revocable living trust, you will work with, on all of these suggestions, you're going to work with an estate planning attorney to complete advanced tax planning strategies and minimize the amount of estate tax liability that you have. In a revocable living trust, you currently have a lifetime exemption of $5,450,000, and more than likely, the Turners would not have any estate tax issues if the tax exemption remains at that level. However, that tax exemption level could change in the future. So you want to make sure that you have a revocable living trust that could address those issues. With that being said, married couples can pass along an unlimited amount of assets without any tax implications. So you want to make sure that the accounts are properly titled, and those that aren't properly titled are titled within the estate planning process through the will or the trust. Those are my recommendations. Again, I suggest you meet with an attorney to draw up the proper documents, and I would like to set up our next meeting to discuss additional elements of your financial plan. Is there any questions? Okay, great. Have a wonderful evening, and thank you for coming into our office.